LME3701, Section A, Legal Research, General Themes. 1.1 Introduction to Legal Research. The saying knowledge is power is one you will have heard frequently in your life. Have you ever stopped to consider the meaning of the word knowledge? Knowledge in the context of research is not simply an accumulated mass of facts and figures, but should rather be thought of as a database which you can access to solve problems in everyday life. In the case of legal practitioners and academic writers, their knowledge database is frequently full of legal knowledge that is used, for example, to solve a legal problem for a client or present an opinion on a specific legal matter. The wealth of knowledge is established during undergraduate study when lecturers lead you in building a knowledge base in various areas or fields of law. You may, for example, have the foundational knowledge of the law of evidence or labor law within your legal database, and are thus equipped to use that existing knowledge to answer questions and appear in court on behalf of a client. But knowledge is not static. It changes and develops into new knowledge. The question is then, where does new knowledge come from? In the case of law, there are various answers. One that comes to mind immediately is judicial interpretation through case law. The courts analyze and develop the law as it stands in order to produce new theories or doctrines applicable to legal problems. The courts also use precedents, which are cases decided in the past. Another source of knowledge generation is legislation. Legislative drafters use new legislation to fill the gaps in the law or to create new law for specific purposes relevant to society. A third avenue for the creation of new knowledge is academic research. As a law student, you have already received the basic principles of law in various subject fields and perhaps have used research skills in research assignments during your previous years of study. These form the basic tools that will enable you to enter the workforce. However, this is not the end of your legal training, and you will require advanced research skills to contribute to the creation of new knowledge in order to, for example, assist clients research legal problems or interpret and develop law from the bench. Further, some of you may wish to pursue postgraduate degrees and perhaps enter academia, which is where the academic legal research becomes particularly relevant. Research is a lifelong learning process that will enable you to evaluate existing knowledge, criticize knowledge, expand knowledge, and eventually contribute to the development of knowledge. The ability to create and, in some cases, manipulate knowledge makes you a valuable asset to employers because it demonstrates higher level thinking and ingenuity. The purpose of guiding you through the research process is to equip you with the skills and aptitudes necessary for creating knowledge independently. In this process, you will learn that there are different forms of knowledge and that not all of them will assist you in completing research. Among the types of knowledge are, for example, first, itemized knowledge. This kind of knowledge, often called general knowledge. It is factual. For example, the death penalty, a form of sentencing in South Africa? The answer is obviously no. This form of knowledge is useful, but does not tell you much more than there is no death penalty in South Africa. Of course, if you are asked to research the historical significance of the death penalty in South African criminal procedure, the fact that it is now not used is relevant and can be linked to a variety of other facts to demonstrate your point. But it is still factual or explicit knowledge. The itemized knowledge claim would then require research in order to be extended to become evidence-based knowledge. Second, opinion-based knowledge. This is a kind of knowledge based on the thoughts and interpretations of people. For example, if we took a survey and asked, should the death penalty be allowed in South Africa? We would receive a variety of responses from people based on their personal experiences and thought processes. This does not, however, constitute knowledge, merely opinion. Often if opinion is questioned, It does not have any basis other than subjective thoughts and emotions. It is, in other words, not evidence-based knowledge. Note, however, that this type of knowledge can contribute to the statistical research where a researcher tries, for example, to establish what percentage of a particular population does or does not sanction the death penalty as a form of sentencing. Third, evidence-based knowledge. This is what we try to teach you to produce through the research process. Evidence-based knowledge stands the test of cross-examination and counter-argument and is supported by authority. The facts you learn during your studies this far are the tools which will allow you to produce this type of knowledge. Legal research allows you to expand, analyze, and criticize knowledge, and then to suggest new interpretations or applications of legal knowledge. Evidence-based knowledge requires you to substantiate everything you claim to be true or correct. This, an academic statement without authority or evidence, is of no consequence. Evidence-based knowledge has certain defining characteristics. The first of which is evidence-based knowledge is aimed at filling a gap in existing knowledge. It is not knowledge for the sake of it, but rather knowledge that aims at curing a defect or developing an existing knowledge schema or suggesting a new form of knowledge to produce. The second of which is it takes its lead from existing knowledge in the field. Existing knowledge usually consists of theories or principles that are used to solve particular problems. This is the basic knowledge of a particular legal field. If your research interest is, for example, plea bargaining in the criminal process, you would not be able to produce new knowledge if you did not know the content of the specific legal instrument, aka Section 105A of the Criminal Procedure Act 51 of 1977, which would form the basis of your research interest at the very least. Existing knowledge includes the work of authors who argue for or against specific points or areas of law. Court judgments also form part of the existing knowledge base for legal research. Third of which is evidence-based knowledge is incremental. It builds on existing theories and knowledge. The existing theories and knowledge are analyzed and/or criticized by role players through research. If you do not know who the main theorists and role players are within your field of research, you lack the basic literature for building knowledge in that field. Thus, it is important that a theoretical framework forms part of your research. Thinking of existing literature as a debate in which all those interested in a specific field of research have a conversation on a particular point of law. They do not always agree with one another and may use various tactics to convince each other of a particular point. These arguments can occur among all knowledge generators, from the most inexperienced researcher up to subject specialists and senior legal practitioners. During this process, knowledge generators both engage with existing knowledge and build theories for new knowledge. These people build legal literature for the production of new knowledge. All knowledge generators, from the inexperienced to the most senior, have a contribution to make. The only requirement attached to adding knowledge is that the analysis, criticism, or interrogation is attached to a knowledge claim substantiated by reference to authority. In other words, it demonstrates evidence supporting its point. The fourth of which is claims are central to evidence-based knowledge. A knowledge claim is a statement about a certain topic or aspect of law that is substantiated by reference to authority. The knowledge claim is thus evidence-based. A central knowledge claim is usually comprised of a series of smaller knowledge claims that holistically build up an argument on an aspect of law. Evidence in the legal field usually takes the form of existing, proven, reliable knowledge, and hence are advised not to simply accept a source without examining it for authenticity and reliability. You will not always agree with the evidence that already exists. However, as you develop into a sophisticated researcher, you will challenge existing evidence by making evidence-based knowledge claims of your own. Your knowledge claims are then deposited into the knowledge database for others to use as evidence and to concur with or dispute using their own evidence-based knowledge claims or theories. Fifth of which is evidence-based knowledge, and the process of analysis, criticism, debate, and so forth is how new knowledge is generated in specific legal fields. LME3701 is designed to introduce you to various concepts originating from the field of legal research. These themes are discussed in general in the remainder of Section A of this guide, and thereafter selected aspects are practically applied in Section B, where we discuss the requirements of a research proposal at a Unisa College of Law. Our point of departure is defining the nature, scope, and content of legal research. Section A, Legal Research, General Themes 1.2. Classifying legal research. 1.2.1. Defining legal research. Legal research is the process of finding an answer to a legal question. Sometimes legal research can help to determine whether a legal issue is a case of first impression, that is unregulated or lacks legal precedent. Virtually every lawsuit, appeal, criminal case, and legal process in general requires a degree of legal research. Legal research can also be driven by policy considerations when, for example, law reform commissions investigate particular social aspects of daily interaction which require legal regulation. From your perspective, legal research forms that part of your undergraduate studies where you are no longer confined to textbooks, but are rather asked to identify, analyze, critique, and report on a certain aspect of the law as a tool for social interaction and the regulation of human conduct. Legal research is conducted for a variety of reasons, but in essence, the purpose behind legal research is to identify the sources of law applicable to understanding a legal problem and then to find solutions to the identified problem. The first steps in legal research is the identification of a problem or gap in existing knowledge. More on this step can be found in Section B of this study guide. In the context of this module, Tutorial Letter 101 sets out a legal problem that we wish you to investigate using legal research methods. Thus, the gap or problem has already been clarified for you. This approach was adopted to ensure the uniformity of assessment in this module. In a real-life situation, you would identify the knowledge gap through your reading of the law or perhaps through your daily interactions with the law in a practical context. In order to conduct legal research, one must have legal information. Therefore, legal research is based on legal information. As you know from your early undergraduate studies, specifically IRM 1501, legal information or sources of law can either be primary or secondary legal information. First, primary sources are binding law codified in legislation, common law, regulations, and case law. This is sometimes referred to as black letter or doctrinal law. Secondly, secondary sources comprise information that is not legally binding, but rather explains or critiques primary sources and legal theory. Secondary sources include the writing of academics and other contributors. They are not binding, but can be used as persuasive authority to support a binding evidence-based knowledge claim. Legal research, much like legal representatives in all their forms, are problem solvers. They solve problems based on the sources discussed above. Problem solving is, however, underwritten by legal research. In other words, a legal problem cannot be solved without conducting research, whether elementary or sophisticated. During your studies, you have been required to master a large body of legal rules, many of which you do not remember or which will have become outdated by the time you graduate. What you will remember and retain, however, are the principles that underlie the operation of the law. These include knowledge of the sources of law and the relationship between these sources, the way in which the system of precedent works, the principle of statutory interpretation, the relationship between various organs of state, the various influences on judicial decision-making, and so forth. These will remain long after knowledge of specific legal rules has faded. these foundational concepts form the basic skills for conducting legal research. You may find, for example, that you are not immediately able to answer a question related to whether Section 304 of the Criminal Procedure Act 51 of 1977 applies to child offenders. However, your basic comprehension of the way the law works and how its sources are categorized will enable you to find the source that will provide the answer to the question and how the question relates to higher legal concepts. When it comes to legal research, there is no difference between what a practicing attorney or advocate does and what a law professor or legal advisor does. Although the form in which their research is eventually presented may differ, the basics remain the same. Whether you are answering an assignment question on a legal problem, advising clients, drafting a legal opinion, or completing a research paper, the process and approach will be the same. You should therefore apply the same basic techniques in all your legal research. In essence then, legal research can be defined as the methodology and approaches used by legal representatives and other legal knowledge generators to solve complex legal problems within a changing and evolving social and legislative setting. The purpose of research is to answer questions, test theories, and establish facts through inquiry and investigation. In its simplest form, research refers to a search for knowledge. It is the scientific and systematic search for information on a specific topic through a form of scientific investigation. In other words, research is the primary vehicle through which we build evidence-based knowledge. Legal research problems cannot be solved unless they are congently framed. Research starts with the framing of a legal question, problem, or statement. This informs the reader of the gap you aim to fill with the new evidence-based knowledge. This aspect is discussed practically in Section B of the study guide. Remember, not all legal research is necessarily good legal research. Ask any professor who has submitted a research article for publication to a journal, and they will tell you that the process of peer review is critical and forces one to reflect on one's theories and interpretations. We mention this because undergraduate research is subject to the same critique. Your work is guided by a supervisor with considerable experience who will ensure that your research product is sufficiently evidenced to contribute properly to the field of legal knowledge. Legal research is not knowledge for the sake of it and must make a contribution to the existing field of knowledge, or perhaps open a new field of knowledge. In order to do so, it should have certain defining characteristics. The United States National Research Council, quoted below from Briggs, Coleman, and Morrison, states that adroit research first poses important questions that are possible to answer. Second, relates research to available theory and seeks to test the theory. Third, uses methods allowing direct investigation of the questions. 4. Creates a coherent, explicit chain of reasoning leading from the findings to the conclusion. And 5th, can be exposed to critique rather than playing to a gallery of existing converts. 1.2.2 Elements of legal research. Traditionally, legal research has taken two very basic forms. The first is research based on black letter law, also called doctrinal law, wherein the researcher concentrates on interpreting the law as a set of self-sustaining internal principles. This approach starts with the law itself and involves reading the sources of law and framing them into a cogent set of principles or guidelines in order to bring rationality and fresh perspectives to the law in isolation. This approach has little reference to the outside world or how the law practically affects human interaction. The second form of legal research can be summarized as law in context. Its starting point is not the law, but rather challenges experienced in society. This approach asks how the problem can be solved and not what the law dictates. In some instances, it frames a societal problem caused by the law. In other words, it asks whether existing law is good law or contributes to societal problems. These two approaches are not the only approaches to legal research, and many other methods of legal research are used in the legal context. For your purposes, we will concentrate in the remainder of this guide on those methods which are pertinent to undergraduate studies and which will provide the basic skills necessary to eventually reflect on and adapt methodologically when you pursue legal research in your later careers. Regardless of the form of legal research, the elements remain the same. First, research is a human activity. It is something that we as humans, with all our faults, preconceptions, and influences, undertake. It is never value neutral, but is nevertheless part of what makes us who we are. Therefore, legal research in particular is to a certain degree subjective, because it relies on humans to interpret existing theory. This is different from research, which is scientific methods such as statistical analysis to validate theories. Secondly, research is a communal activity. In order to complete a research paper successfully, you are required to interact with your supervisor, with other scholars through their work, with what has been written and decided in the past, and so forth. You become part of a conversation between the past, the present, and the future. Third, what is regarded as acceptable research in law is very different from acceptable research in, for example, physics or psychology. As you work through your research, you will learn what is acceptable and what is not. A good indication can be found in articles written by law professors or other subject specialists. You will further find that the research methods used in law are often criticized as being unscientific and open to subjective interpretation, a point that many legal scholars continue to argue is untrue. Fourth, the purpose of legal research is the study of legal problems and issues in order to increase our understanding of how the law functions, what contribution it makes to human interaction, and how it can be improved in its function and effect. Fifth, legal research involves creative, systematic, and original work that explains how the law functions. In addition, it embraces the critical evaluation of this functioning. And 6. At the most basic level, legal research involves critical engagement with an intellectual tradition. From what you have read in the study guide this far, it is clear that there are different types of research in general and different types of legal research in particular. Below we survey different types of research in general and thereafter discuss 3 specific types of legal research. We nevertheless reiterate that it is possible to use most of the types of general research methods in law, and law is not bound to any of the types of research we discussed below. 1.2.3 Types of research. There are many types of research, which can be classified in different ways depending on the methodology of the research, the knowledge of it produces, its target audience, and the research problem that it seeks to investigate. The following are examples of selected basic types of research or research approaches adopted mainly from Auditory and Mountain. The list below is not exhaustive, and other types of research can be added to it depending on the particular field in which the research is being conducted. Table 1. Types of research. Descriptive research. It includes surveys and fact-finding inquiries of different kinds. The major purpose of descriptive research is a description of the state of affairs at present. It aims at clarifying what is. It can use either qualitative or quantitative research methodologies, but does not strictly fit into either. An example of a descriptive research project may be, for example, how many students use the Unisa system and what do they use it for. You can see from the basic research question that both qualitative and quantitative data will be necessary to come to a valid conclusion. Okay, secondly, analytical research. In analytical research, as opposed to descriptive research, the researcher is required to use facts or information already available and analyze these to make a critical evaluation of the material. Using the example provided above, let us assume that there is already a study available on how many students use Unisa and what they use it for. From an analytical perspective, another researcher may postulate that the Unisa use is low because the interface is not user-friendly, and may then use existing data to extend the research and ask further questions based on it. Thirdly, applied research. Applied research, or action research, as it is sometimes called, aims at finding a solution to an immediate problem facing a society or an industrial business organization. It is not knowledgeable for the sake of it. It seems to ultimately improve a situation in practical terms. This research approach helps practitioners to investigate an aspect of their practice in order to solve the problem at hand and offer ways to improve the environment within which the problem is located. Using the same problem posed above, an applied researcher may, for example, conduct applied research on which strategies are best suited to encouraging students to use Unisa. Fourth, quantitative research. Quantitative research is based on the measurement of quality or amount. It is based on numeric figures or numbers and is applicable to phenomena that can be expressed in terms of quantity. Quantitative research has as its objective the development and deployment of mathematical models, theories, or hypotheses pertaining to phenomena. Using the same example provided above, a comparative quantitative researcher may research, for example, what percentage of men and women use Unisa on a daily basis. Or using a descriptive quantitative method, the same researcher may ask, what are the most important factors influencing the use of Unisa by female students? Fifth, qualitative research. Qualitative research, as opposed to quantitative research, is concerned with qualitative phenomena. For example, phenomena relating to or involving quality or kind. It makes use of various methods, such as observation and case studies. Using the same example provided above, a researcher may ask, for example, what specific challenges do students born before 1980 experience when using Unisa? In order to answer this question, a researcher may rely on, for example, case studies or observational research. Sixth, conceptual research. Conceptual research is research related to some abstract ideas or theory. Philosophers and thinkers generally use it to develop new concepts or to reinterpret existing ones. Traditionally, this type of research involves thinking about a problem. For example, what causes students to commit plagiarism in exams? 7. Empirical research. Empirical research relies on experience or observation alone, often without due regard for system and theory. It is database research, coming up with conclusions that are capable of being verified by observation or experiment. Empirical research can be either qualitative or quantitative. An empirical study uses primary data, such as surveys, experiments, case studies, etc., or analyzes existing information, such as criticism of text, content, historical studies. Empirical studies generally rely on comparative methodology, evaluation research, historical studies, or textual analysis. Non-empirical studies generally rely on philosophical analysis or literature reviews. 8. Experimental research. It requires the researcher to intervene in the problem in its natural setting and to be able to control a number of variables to determine a causal relationship between two or more properties of an individual or unit. Experimental research in the field of law is extremely rare. As mentioned earlier, legal research, in particular has generally relied on a black letter law approach, or an approach which perceives law in context. This can be loosely referred to as doctrinal research or descriptive research and empirical research. 1.2.3.1 Doctrinal Legal Research. Doctrinal legal research is the type of legal research you are most familiar with at this point of your legal studies. According to McConville and Shui, it aims to systemize, rectify, and clarify the law on any particular topic by a distinctive mode of analysis to authoritative text that consists of primary and secondary sources. It relies on the assumption that the character of legal scholarship is derived from the law itself. This type of legal research may be more familiar to you if you consider it to be the basis of the now famous Firak method. Firak requires a law student to identify the facts F of a particular legal problem, determine the issue I arising from the facts, identify the rules of law, that's the R, of law governing the particular issue identified, apply A, the rule of law as identified to the issue, and eventually come to the conclusion, C. This approach presupposes a specific set of skills such as the ability to find the law, use the law, relate the law, and present the law in a clear and cognate format. It is founded on the assumption that the ability to reason and rationalize the law as it stands will allow the researcher to research conclusions and perhaps make recommendations as to future legal reform. We have presented this method here in a very basic format from the perspective of an undergraduate student, but the reality that this method can be found in the majority of postgraduate and academic research, albeit in a more sophisticated format. There is nothing particularly wrong with this method of research, but it must be seen for what it is, namely an internally reflective system of legal analysis. The difficulty with this type of research is that it is not interdisciplinary and does not make use of qualitative and quantitative legal research tools which give a broader perspective to a dimension of law while linking it to the society which, after all, the law regulates. Many law faculties have moved away from pure doctrinal research towards teaching other legal research methods. 1.2.3.2 Empirical Legal Research or Socio-Legal Studies. The doctrinal method of legal research can be criticized for its rigidity and the fact that it is an inward-looking system of legal analysis. Different schools of thought will interpret this statement differently and have differing opinions on its validity. Law is and remains a social phenomenon. As the Latin maxim runs, ubi societas ibi jus. Where there is society, there is law. The socio-legal research method simply does this. It contextualizes the teaching of law to the society which it regulates. The relevance of using other disciplines such as psychology, political science, international relations, sociology, anthropology, criminology, history, etc. contributes to a broadening legal discourse. After all, as the adage goes, the law regulates the human being from the cradle to the grave. It intertwines with several other areas of human knowledge and essentially regulates them in all their manifold existences. It is so all-compassing that it is not possible to convince any of the other academic subjects where the law does not have a say. In response to this, in recent literature, there is strong evidence for the growth of interdisciplinary methods of legal research, such as socio-legal studies and feminist legal studies. The use of empirical research in law moves away from strict doctrinal analysis of primary sources and asks the researcher to reconsider the law as a social phenomenon. This borrows from or embeds research methods from other fields such as the humanities or social sciences in its approach to legal studies. The idea of this type of research is to move away from seeing law as a self-standing set of guidelines and principles, and rather move towards the study of law within a broader social or political context. Using these methods, the researcher is able to gather empirical evidence to answer a research question. This message forms the bridge between law in textbooks and law in action, and is concerned with how the law affects society. In some cases, it is used to suggest that the law itself may be the cause of a problem in society, as opposed to being the solution to a problem. The approach to legal research is distinct from the pure method, the doctrinal legal research, and employs a wide range of both qualitative and quantitative methods. It must be understood that recent trends indicate that pure legal research and interdisciplinary research can be used simultaneously to enrich research findings. 1.2.3.3 International and Comparative Legal Research. We live in a world of global interdependence, and this fact is not lost in the legal field of research. Most legal research, whether it takes a doctrinal or empirical form, relies on reference to a variety of international instruments, foreign domestic law, and the interface between private and public international law. This type or form of legal research is widely acknowledged as facilitating understanding of the operation of internal legal systems, on the formulation of public policy, and assists a legal researcher to develop the skills of critical thinking through engagement with comparative schools of thought. The above types of legal research are by no means exhaustive, as is evident in the variety of methods that have developed, for example, the feminist legal studies and critical legal studies. However, no one course in legal research can cover all the types of legal research, and in this module, we limit ourselves to basic legal research skills, often found in the doctrinal or black-letter law method. In your postgraduate studies, you may find that you will rely on other methods of research in order to prove your point. Section A 1.3 Conducting Research in Law. From our brief introduction above, you will have noted that legal research is not a simple matter. It does not correlate with simply writing an essay, but rather is dependent on planning and effective execution. In order to make these nebulous concepts more practical, the research process, in its fundamental aspects, consists of, first, planning of research, secondly, executing the research, and thirdly, reporting on your research findings. In other words, the research process can be represented simply as plan, execute, report. Section A 1.4 Research Design, Planning and Methodology. This part of Section A concentrates on research design and methodology. You may ask yourself how important this aspect is to overall research. The answer is simple. It is imperative to any research project that you undertake. We like design and methodology to an architectural design for a house, or to drawing plans for some kind of construction. Its purpose is to ensure that the eventual structure is architecturally sound. This, metaphorically, is the purpose and impotence of clear research design and methodology. 1.4.1 Research Design or Planning. There are different types of design serving the same purpose, which is planning the work to be accomplished and enabling a visualization of the product in a smaller, more condensed form, even before construction begins. This design tells a story and gives us a foretaste of what is to come. The same goes for a research design or proposal, which is aimed at giving an impression of what the research is going to be about and what the final product will be. Every kind of research requires a good design or plan to ensure that the research is carried out properly with as few difficulties as possible. With a good plan, the researcher is able to anticipate the different areas of difficulty in the research process and plan ways to mitigate such difficulties. Thus, a research design serves as a guide and helps you as the researcher to reach your goal safely, effectively, and efficiently. Young views a research design as a plan of action, a plan for collecting and analyzing the data in an economic, efficient, and relevant manner. She goes on to assert that the research design helps the researcher to save time, energy, and money, and thus make the research study fruitful and effective. In order to plan your research, you first need to know what you want to do. What are the questions to be answered, and have they been formulated properly? After formulating the questions, you then need to plan some more. Firstly, it is advisable that you write out a plan of action to follow. What sources do you require, and in what order are they applicable? How do you find the following sources applicable to your research problem? First, primary controlling authorities, primary persuasive authorities, secondary authorities, and sources for checking and validating authorities. Secondly, you need to keep a good record of every item that you find, including what it says and the citation of the authority and page number where the material is found. This is the part of keeping track in research. Keeping a record of every item will avoid frustration because one cannot find the book, article, or source. A well-prepared record of the findings can be used as a skeleton or outline for the written work and can pass as a first draft research proposal in our context. As you do research, you will probably discover that there are a number of elements required for the rule on the legal issue with its own exceptions or defenses to the rule. Alternatively, you may find authorities that provide for the law, case law, limiting factors, policies, and the like. Capturing all of these in your plan helps in developing a skeletal structure for your research and makes it easier for you to fill it in and populate it as you go along. As indicated above, our purposes in an academic legal research context. A research plan can also serve as a draft research proposal. It is a proposal that is presented to your supervisor that sketches out your planned research and the way you envision concluding it. This is the aim and purpose of the module, namely that you will know how to draw up a good research design or proposal based on the research problems provided to you in Tutorial Letter 101. There are some key characteristics of a good research design. Thus summarize these as follows. First, it must have specific and clear objectives. It must not be vague or misleading. It must be precise and specifically express its objectives. In other words, what the research sets out to do. Secondly, it must maintain consistency. It must not be based on emotional or biased feelings, but rather on a sequence of thought and analysis. Third, it must contain a hypothesis, and a good one at that. A good hypothesis stems from an imaginative idea, which draws logical consequences from either empirical or non-empirical testing. Fourth, it must provide for the techniques for data collection. Fifth, it must interpret data scientifically, in other words, in a systematic, logical, and scientific, with proof manner. Six, it must provide an operational framework, both in terms of the time and reach, geographical, societal, etc. Note that while a research design will have its minimum qualification requirements, it is not cast in stone, and you as a researcher may add other areas that you deem necessary to the proposal and your particular research problems. We now turn to the how two part of doing research by examining research methodology. 1.4.2 Research Methodology. You are probably wondering what methodology is and how it relates to research. A further question should be whether methodology includes method and vice versa. Incidentally, an important question to be raised here is whether method and methodology mean the same thing or not. This distinction is very important as the two terms are often confused and, unfortunately, used interchangeably, even by notable authors on the subject. At first year level, you were introduced to general research methods, and here we extend this knowledge. Research methods are generally concerned with how to do research and include the techniques and approaches that the researcher adopts in carrying out the research. Research methodology, on the other hand, can be defined as a study of techniques and approaches to determine the reason for particular techniques or approaches. Many authors have attempted to make this very important distinction. Kruse, for example, defines research methods as the skills and practical ways to go about doing research and presenting the research, whereas research methodology is defined as science studying research methods and not an exposition of the methods themselves. In other words, it is a science in itself, which examines the different features and issues that underlie research methods. Thus has further attempted to distinguish these terms, stating that research methodology is the techniques involved in the pursuit of pursuing research. Methodology is important and vital in the process of carrying out research or to gain new knowledge. It improves standard guidelines to the researcher, includes the entire process to gain information about the phenomenon of research, and in the wider sense includes philosophy and procedure of holding research. Research methodology examines the different techniques, tools, and processes used in research. It is through methodology that researchers are able to identify approaches for conducting their research activities. For ease of understanding, we depict these differences in the table below. Research method, techniques, processes, and tools for carrying out research, which focuses on the research process as well as the instruments and procedures used to conduct the research, in other words, the technical aspects of research. Research methodology is a scientific study of the research methods that have been adopted by the researcher, which involves studying the different steps that have been adopted by the researcher to study and address his or her problem and the logic behind such steps. And lastly, a branch of knowledge dealing with general principles or axioms for the generation of new knowledge, referring to the rationale and philosophical assumptions underlying research in the human sciences. From the above discussion, you can see why the two terms are easily confused. For the purposes of this module, make sure that you are able to distinguish between them and take note of the differences as you embark on your research. Another important issue to discuss in this section is approaches to research. In dealing with this, the thinking must be, how do I do this research and what should my approach be in carrying out this research? Section A 1.4.3 Approaches to research or types of research. Note that there are different approaches to research. These approaches cut across different fields of research and can be used and adapted to suit different fields. However, some approaches are more suited to particular fields of research than others. Hence, the type of research and the goal of the research being carried out will influence the approach to be adopted. You therefore need to know what approaches are more suited to your field of legal research and what approaches are better suited to other fields. At 2.3 above, you were given a table showing different research types or methods and approaches. These are the more common types of research, but the list is by no means exhaustive. Note that these approaches are not used exclusively, and there are usually overlaps in the research approach adopted at any time. Depending on the research, certain approaches will tend to be more suited than others. As indicated in 2.3 above, some of the research approaches are particularly important for legal research. Of these, some are more common than others, and we will briefly highlight those that will be pertinent to your legal research in one way or another. 1.4.3.1 Qualitative Research versus Quantitative Research. These are commonly known as the basic type of research. Qualitative research aims to answer the question why. It endeavors to describe and explain certain phenomena or positions within a wider context. Here, the data collected consists of unstructured information in the form of words, objects, and pictures. Statistical analyses are not employed in qualitative studies. For the legal researcher, data collection will include a review of the literature, case law, statutes, and other sources of black-letter law, usually referred to as law in books or doctrinal law. Qualitative research also tends to be more subjective because much of the result depends on the researcher's interpretations of the data and the primary and secondary sources. Typically, a qualitative research approach relies on a doctrinal or black-letter law methodology. Quantitative research, on the other hand, focuses on data collection in the form of numbers and statistics. The types of data will be subject to statistical analysis, which allows for students that are more objective. Allows for results that are more objective. The ultimate aim of quantitative research is to explain certain findings through statistical models. A quantitative approach, according to Kotori, can be further subclassified into inferential, experimental, and simulation approaches to research. The purpose of inferential approach to research is to form a database from which to infer characteristics or relationships of population. This usually means survey research where a sample of population is studied, questioned, or observed to determine its characteristics, and it's then inferred that the population has the same characteristics. Quantitative research can be applied in various research types, but is typically found in action-based or analytical research. Note that in law we generally rely on qualitative research rather than quantitative research. Although nothing precludes the use of the latter, keep in mind that if you intend to use quantitative research design, you will be required to apply for ethical clearance from the College Research Ethics Committee before you can proceed with the research. A mixture of the two methods is also acceptable. This approach is known as mixed method research. A mixed method research project collects both qualitative and quantitative data and uses them either concurrently or sequentially in the study. Within the traditional doctrinal legal research methods, historical or comparative approaches are usually preferred as the tools of research. These approaches are more commonly used due to the nature of legal studies. 1.4.3.2 Legal Comparative Approach. The legal comparative approach entails a study of how your research topic or issue is dealt with by the different legal systems, rules, and institutions of the world with the aim of obtaining critical insights. This approach involves a method of study and research aimed at examining and comparing the principles or methods in different systems of law in order to achieve the purpose of the research. The comparative method goes beyond a mere listing of the legal rules that exist in several jurisdictions. It must have a purpose and an end. In the case of legal research, the purpose must be to compare and discuss the similarities and differences found in these legal systems in order to be able to advocate ways in which your issue could be better dealt with in your jurisdiction. For the purpose of clarity, take note that the comparative approach is, first, not a study of a single solitary foreign system of law and not a study with mere incidental references to other legal systems. In adopting a comparative approach, the study must involve an explicit and systematic study of at least two legal systems. Note that for the purposes of postgraduate research, the comparative jurisdictions are usually numerous. A comparative method approach can take the form of either a macro comparison or micro comparison. Macro comparison refers to a study of legal systems or groups of legal systems as a whole, whereas micro comparison concentrates on the study of particular legal institutions in two or more legal systems. For example, the systems of bail in various legal systems. Note that at this level of your LLB studies, your research is geared to a micro comparison, where you will be involved in research on particular rules and/or institutions within legal systems. In order to achieve this, it is important to have an understanding of the grouping of legal systems. When legal systems share similar characteristics, they can be grouped into units referred to as legal families. Groupings into legal families were traditionally done ethnocentrically along the lines of the Roman, Germanic, or Anglo-American legal systems. However, in acknowledging the existence of other cultures and societies, Duplessis has provided a more contemporary grouping as follows. A. The Anglo-American systems, for example, the USA, New Zealand, Australia, and the UK. B. The Roman Germanic systems, for example, the European legal systems. C. Mixed legal systems, such as South Africa, Canada, Zimbabwe, Botswana, Lesotho. D. African and other traditional legal systems, for example, African customary law of the Maori and the Inuit, native tribes in the USA and Canada. E. Religious systems, for example, Hindu, Jewish, and Islamic law. F. Eastern European legal systems, for example, Latvia. G. Eastern legal systems, such as the Chinese and Japanese law. H. South American legal systems, for example, Brazil and Chile. Note that these are by no means exhaustive, and these systems could be grouped according to other characteristics. However, this grouping now caters for the phenomenon of legal dualism, legal pluralism, and mixed legal systems found in practically all African and Asian countries. 1.4.3.3 Legal Historical Approach. The historical method of legal research is employed when a problem relating to a legal figure or feature of law has been identified, and the origin of that figure or feature is traced or its development over time is investigated. As you are aware, law develops over time and often incorporates the norms of specific periods of history. Law is influenced by a wide range of aspects, such as political and social policy. The historical method therefore aims to analyze these developments in law and perhaps suggest whether contemporary use is based on incorrect assumptions or reforms. According to Duplessis, legal history is more than the study of the development of material legal norms. It also includes the analysis of these rules in the light of the external legal history, the economic, cultural, political, social, philosophical, and religious development. The development provides answers as to why a legal system has certain characteristics. The lawyer should not be taught only to use the legal history to find the sources of the present-day law, but he or she must be able to use his or her knowledge to propose alternatives for legal development. He or she must be able to break through the boundaries of the history as is stated by Professor Visser of the University of Cape Town. When choosing this method, you will generally focus on a single legal system in one jurisdiction over time. When you understand the development of a legal system, it may be possible to suggest future law reform. When using this method, it is important to indicate in the research proposal the exact time frame you will examine. Depending on whether you are investigating a specific rule or legislation, different procedures apply to the way you investigate the historical development in your eventual thesis or dissertation. Generally, historical research is chronological. It is advisable to discuss the exact procedure to follow with your supervisor, who will be in a position to advise you on the chronology to follow in regard to legal research in specific fields or on specific topics.